Very good. All right, Chris, we'll throw it over to you.
All right, first, a question for you, Jason. Can you hear me?
I can.
Have you ever seen, do you know who Zach Galifianakis is?
That sounds familiar, but it's not coming.
He's a comedic actor.
Okay.
And he hosts this show on YouTube called Between Two Ferns.
Oh, okay. Yeah, I know.
Are you familiar with Between Two Ferns?
Not that it's something that I watch all the time, but I am familiar with it.
Yeah, your webcam kind of has that feel to it.
It's not a fern, but
I know. It's not exactly like it, but it kind of has the Between Two Ferns feel to it. So it's kind of funny.
Oh, I need to move that over a little bit.
All right. So let's go ahead and.
I'll turn the webcam off so I'm not a distraction. Thanks, Chris.
Let's go ahead and get started. All right. Are you exposed? Does governmental immunity protect your entity? So that's what I've been asked to talk about briefly today. So I'll talk about that over the course of the next 30 minutes or so. So the simple question relative to exposures is this a big case? So is this going to be a big claim? And if the answer to that question is yes, it's a big claim, then you are going to be exposed as an entity. If not, then maybe you're okay. I'm going to have to take at least one of these headphones off because I can't hear myself talk at all. This is really bizarre. I can't tell if I'm coming across at all. All right.
You sound good.
If the answer to that question is no, it's not a big claim, then maybe you're going to be okay. Maybe immunity will protect you as an entity. So we'll spend a little time talking about that today. How we'll cover it is, one, talking about the governmental immunity statute. We'll talk a little bit about the caps. We'll talk about exceptions to the cap and immunity. Then we'll talk a little bit about forum shopping and then your insurance coverage. And then we'll go over, I want to say 3 or 4 cases, maybe 3 cases that I've included in this presentation. So the first question is the tort itself, is the claim that's being presented against you, is it going to be immune from prosecution? Essentially how the immunity statute is set up is it's established to give governmental entities protection from any type of tort that's presented against them if the governmental actions themselves are unique and essential for governmental purposes. So it's kind of designed to put an umbrella over all governmental entities for acting as governments. So there are specific type of activities where that philosophy, that statutory provision is challenged, and it's usually involving stuff where you're governing golf courses, hospitals, ambulance services, pest control, sewer and water. All of these types of functions that governments will do and we're involved with as your insurance company raise questions about immunity in and of itself, because these types of functions aren't necessarily unique and vital for governmental services, so thus not necessarily protected under the immunity statute. So again, it becomes a question of function being both proprietary and unique in order for immunity to be raised as a defense for you. So in the examples that I've given here above, these functions are questionably unique to government, so they probably will not be immune from prosecution. So even embedded in the immunity statute itself, there are waivers to immunity. So if you have any kind of contractual obligations, that's going to be waived under the statute, and you're going to be subject to prosecution if you've committed a tort. obtaining possession or acquired title of real or personal property, any kind of takings claims or inverse condemnation, those are waived under the statute from immunity. Negligent destruction of property in your care, custody, and control, that's also waived as well. Unsafe roads, unsafe buildings, and so on and so forth. So there's a whole host of these waivers under the statute. So just by virtue of acting as a government in a governmental capacity does not necessarily make you immune from prosecution. There are certain waivers, as I've listed here above. These are the more common elements where immunity has been waived under the statute. So if in the event you are subject to prosecution, you could potentially be protected by the cap. As of July 1st of this year, it changes every 2 years. The cap is $703,000 for any one person and up to $2.4 million bucks in the aggregate for any one occurrence for multiple parties involved in an accident. If it's a property damage case, the cap for those cases is $281,300. So this is how the statute reads by way of a cap, but you aren't necessarily insulated under the cap. There are certain exceptions to the cap in and of itself. So I mentioned before, takings is an exception to the immunity provision, meaning it's waived any kind of takings claim. So if it is a takings claims are not subject to the cap. You have the full exposure for any type of takings claim. So just under the statute itself, there are certain waivers and exceptions where you can be prosecuted and potentially not be subject to the cap in and of itself. On top of that, not only do we have interpretation of the statute or the reading of the statute in and of itself, we also have case law that we have to impose on top of the statute for purposes of interpretation. And this is one of the biggest cases that we normally look at when you have a large exposure as to whether or not the immunity statute in and of itself and or the caps will be constitutional. It's called the Berry test. And essentially what the Berry test says, what all of this narrative says here, is that the law of our land provides for open courts. So in the event that you have a prosecutable case that you want to present against a defendant, it should be subject to the open court provision of the law. So you should be able to bring a case, you should be able to bring a case against anyone in any given court that has jurisdiction over it. So in order to pass the Berry test, meaning whether or not the immunity is going to be constitutional, it has to stand up to two separate parts. The first part is whether or not the case or the claim in and of itself can be handled under due course of law, meaning does the case in and of itself have a value that is under the cap. So if you have, let's just say, $100,000, a case that's only worth $100,000, that would be prosecuted under due course of law anyway. So in other words, the cap doesn't even come into question. So that being said, the immunity cap will be deemed to be constitutional. Or secondly, whether or not the law in and of itself was engineered to rectify a clear social or economic evil. So if the immunity statute in and of itself is looking to eliminate some kind of inherent evil that someone would unjustly be enriched by, then it would also be found to be constitutional. So as long as the case is or can be prosecuted under due course of law and or be deemed to eradicate a clear social or economic evil, then the immunity statute would probably be deemed to be constitutional. So that's just at the state level, whether or not immunity will apply, immunity in the caps. So again, back to the open courts provision. Not only are you looking at the state courts, you also potentially have the federal courts involved. And when you're looking at federal court or federal laws, then we don't even have immunity statutes to consider. So as long as the court in question has jurisdiction over the case, then again, the law of our land says that you can bring a case in front of that court. Jurisdiction usually speaks to the subject matter and the person in and of themselves. So as long as the court has jurisdiction over both the subject matter and the person, then it's allowed in front of that court, because we do have a dual jurisprudence system in our country. And here are a couple of bullet points about the differences between the two. State courts have what's called general jurisdiction, meaning that they essentially have jurisdiction, or they can govern over any case of law in that given state. The state courts have exclusive jurisdiction in all matters, where the federal courts don't specifically have exclusive or concurrent jurisdiction. The federal district courts, or the basic federal district courts, only have been given jurisdiction over things that have been deemed by our Congress. And Congress is reluctant to deprive the state courts of jurisdiction, and has usually preserved the right of the claimant to pursue the remedy in the form of the claimant's choice. So this is just basically a bunch of points to say that plaintiffs have the capacity to choose the courts that they feel would be best for, or at least would deem the best outcome for them. So why would someone choose a federal court in a case? One, the jury that's selected. In a federal court case, the federal courts have a larger master wheel than what's going to be available at the state court level. The master wheel for a federal court jury can pull from the entire voting district of that particular federal court. The presiding judges are different at the federal court level, and they might feel as though this is a judge that has ruled more favorably for their type of cause in the past. The convenience of the place of the trial for the attorneys or witnesses in the case, and the advantages of civil procedure in federal court versus state court, because civil procedure can be different from one court to the next. So again, in the federal court, at the federal court level, the caps don't apply in those types of cases. But the question now becomes, if I am not immune from this particular case, and it can be brought in front of the courts for prosecution, and potentially it's not going to be subject to caps, my insurance will protect me, right? So in order for that to be considered, there's a couple of elements that need to be taken into consideration. One, you should always start with your insuring agreement. This is language that I took from our policy, and our policy is pretty much modeled after an ISO form. So this is going to be a case in almost all insurance policies. It will read something to the effect of your insurance company name the trust in this particular case will pay those sums that the insurer becomes legally obligated to pay as damages because of bodily injury and property damage caused by an occurrence to which this policy applies. So first, you have to see whether or not the accident or the loss itself is going to be triggered under the insuring agreement. Then if the loss is going to be triggered under the insuring agreement, then the amount that the company will pay is limited to the amount that's described in the limits of insurance. So even if you have an exposure, that's there and is covered under the policy, the max that your insurance company will pay are the limits that you bought under that particular policy, which in our case is usually either $2 or $5 million. So when you're having a discussion with your insurance company, us in this particular case, here are some of the things that you want to make sure that you understand when you're discussing this type of stuff with your account executive. One, how do you define, or how does the insurance company define damages, bodily injury, personal injury, and an occurrence? So you need to have those elements in place in order for your policy to be triggered. If you don't have damages, or if you don't have an occurrence as defined under the policy, then your policy may not be triggered and you may not have coverage. If you do have coverage, if you do have a policy that's triggered for any given loss or lawsuit that's brought against you, then you need to understand what your limits are. And I would, encourage our members, as I'm sure our risk managers would, and I'm sure our account executives do, to purchase as much insurance as you can, or as as is feasible for your given entity. Because we'll talk about a couple of cases on the next couple of slides where the exposures are real and the exposures are significant. So you can get a $5 million policy from us if you're in a position to do that. Make sure that you're doing it. Also understand whether or not your coverage is a wasting policy, meaning whether or not the policy in and of itself, your policy limits, are they reduced by the cost to defend the cases? And in a lot of cases, particularly in cases involving federal courts, those cases are very, very expensive to defend. It's not unusual for us to spend in excess of $100,000, $200,000, $250,000, $300,000 just defending the case. And you need to know whether or not that $300,000 comes off of your policy limit. So if you have a wasting policy, and let's just say we've spent, or your insurance company has spent $500,000 defending a case, and you have $2 million available to you, the question is, do you have 1.5 now available to satisfy a verdict, or do you have the full $2 million available to you? And here at the trust, we have what's called a non-wasting policy. So whatever we spend defending the case, your entire policy limits are available to you in the event that there is an adverse ruling against you down the line. Also, whether or not your policy is an occurrence or a claims-made policy. An occurrence policy meaning any loss that happens within the term of that given policy. So let's just say January to December of 2014. If the loss happened between those periods, then on an occurrence policy, that means you would have coverage for it if it's triggered and not subject to the exclusions. If it's a claims-made policy, that means that the loss would have to be made within that same policy period. So even if it happened between January and December of 2014, if it's not presented, if you don't get a claims notice or a lawsuit until, let's say, after that policy had terminated, even if it happened, let's just say June of 2014, if it's a claims-made policy, that means you may not have coverage. We have, for the most part, what are called occurrence policies here at the trust. And you need to have also a good understanding of the exclusions, what exclusions are in your policy that may limit or remove coverage for a claim or a lawsuit that's been made for you. So even if you have a loss that's been triggered under the policy, it's still going to be subject to the exclusions. So you need to make sure you have at least some kind of running understanding of what those exclusions are and how they may apply to any given loss. And to the extent that you may have, questions or challenges, with your insurance company about their interpretation of the policy, have a good understanding as to how that difference is worked out between your insurance company. So here are 3 real-life cases here in Utah that have been of some pretty significant exposure. The first is Hancock versus Duchesne County. This one was a verdict of $3.5 million against the county for wrongful suspension of a building permit. I believe this is one, and this was actually not a trust case, but this is one where Duchesne County had revoked a license that, or suspended a license that they had previously approved for a, I don't want to say a halfway house, but it was for a house that rehab substance abuse kids who need some help. So in spite of the neighbors or the people in the community not wanting that house, they had already approved the building permit, and suspending it became problematic for the builders. So they got a really bad verdict there. And again, in the case where if Duchesne County only had a $2 million policy, they'd have to figure out a way to come up with that, that additional 1.5 to satisfy this verdict. Also, Tooele Associates versus Tooele City. This is a breach of contract case, one that is subject to the waiver of immunity, because if you recall from earlier in the slides, breach of contract or contract conflicts is one where the statute waives immunity for these type of agreements. They got hit for a $20.7 million verdict for this breach of a development agreement in Tooele City. And the last, this one is actually a trust case. This was in federal court down in Arizona. A $5 million verdict for religious discrimination that took place in the Hilldale, Colorado City area. So that is pretty much the end of the presentation. Just a couple of quick points summary. Big money cases may impose open courts provisions. So in other words, if it is a case that's going to have some significant value to it, one that may be in excess of the cap, don't just assume that the cap is going to protect you. If a court potentially can view that case as a breach of the Berry provision, meaning under any normal circumstances, could this plaintiff get full compensation for his damages? And if the answer to that is yes, then it's likely going to be deemed that the immunity cap is unconstitutional and will not protect the defendant or the governmental entity in that case. Remember that the statute has a list of waivers to immunity, so just because you're functioning in a unique governmental capacity, the allegation against you in and of itself could be subject to one of the waivers of immunity. The plaintiffs can shop courts if the state court is not necessarily a favorable venue for the plaintiff. The plaintiff may want to shop it in federal court. Defendants can do it as well. But if it goes to federal courts, a lot of times it's not going to be subject to the immunity cap in and of itself. Make sure you have a basic understanding of your insurance policy. Again, words that are in quotation marks like bodily injury, property damages, occurrence, those types of things are specifically defined under your policy. So make sure you understand what those definitions are and how they may be imposed for any loss against you. Governmental entities may be and are held responsible for cases in excess of the cap. So I'll talk about that a lot. I'm not going to talk about that more. So any questions out there, Jason? That's the end of my spiel.
I don't have questions here. I believe one respondent raised their hand, but then she put it down. So I don't know if any of you have any questions. You can type those into the chat box or the Q&A box, and I'll relay those to Chris, or you can alternately raise your hand, and I can open up your microphone if you want to ask that question verbally. All right. So I'll ask a question as we're waiting for just a second. So, how would an organization evaluate their exposure to going beyond these caps?
How would they?
You know, what would be the major risk factors? Land use, constitutional type claims.
Oh, that's a really good question, and I wish that I had a simple answer for that. But in the 3 cases that I used in example, those were 3 different types of cases, and it really is just going to come down to the severity of the damages in and of themselves. We've had an automobile accident with a member who did not necessarily have a history of problematic automobile use that had an exposure way in excess of the cap. We've had the religious discrimination, a case that I used an example as yet another example of a case that had an award in excess of the cap in and of itself. So it just depends on how severe the damages were relative to the infraction. It could come, any kind of breach of contract issue, discrimination issue, a 1983, case, an automobile accident, a trip and fall. If the person is hurt severe enough, then the exposure is going to be there. Yeah.
Mm-hmm. Where there's a will, there's a way. Okay. Great. Well, I just got a response back, and it was actually just a technical question, some challenges, and just for everybody out there, apparently we've had some audio difficulties, some going in and out. We have recorded this web event, and we'll be posting it up on the website here this week, hopefully today or tomorrow. And there are a couple of you out there that have had some challenges getting in on the audio. If you want to hang around after the webinar, we'll do our best to figure out how to make that work. Thank you, Chris. I appreciate that. That was very enlightening, and something that we definitely all need to be aware of, and not just count it out that we're covered in every situation up to the full extent. Anything to wrap up, Chris, Doug?
No, just thanks for having me.
All right, thanks so much, Chris. Appreciate it. We'll be doing a quarterly webinar in 2015 involving Chris or something from the claims world, so you can look forward to getting more material just like this. Thanks so much. Appreciate it, everybody. Have a great day.
Thanks.
All right, there's a couple of you folks that if you want to hang around, Susan and Jim. Looks like we're having some technical issues. Let me